relevant to his expertise, which is counsel's perspective on examination, cross-examination of witnesses, potential challenges on multiple locations on virtual platforms with varied connectivities. As you know, that comes with its own challenges. So Kamal will be interrogating that for us, opening our eyes to the pitfalls. And what are the top 5 you must have for effective representation on this platform? So having introduced Kamal, I will ask him to take 15 or so minutes to give us his presentation. I will introduce the speakers as they come up so that you keep their expertise in mind even when they speak with us. So Kamal, it's your mic. We're ready to hear you. Thank you.
Thank you, John. I'm delighted to be speaking to you all. I think it goes without saying that the last few months we have all experienced lots of different types of meetings, webinars, seminars, and of course hearings, which is what we're here to talk about today. There have been a lot of lessons learned through a number of frustrations and a bit of trial and error. And in the process, I think we as council, as tribunal members, have all become IT experts of various sorts. Even those IT dinosaurs amongst us have had to change because of the circumstances. I just want to share some experiences of mine on a personal level. I have been involved in a number of court hearings in the UK, including in the Privy Council, a number of arbitration hearings as counsel and as a tribunal member, as well as case management conferences by audio and video. So a number of common themes have emerged, and that's really what I want to share today to give you some of my own stories. It would be good to hear some of yours when we come to the Q&A. From the council perspective, I've picked up a few common themes which I'll take in turn. The first one is something we all look at when we first get on code, and quite a lot has changed on the dress code as well. A number of my arbitration cases, the tribunal gives guidance on dress code these days because it's the obvious question people ask. I had an email last week from the chairman of the tribunal to say that the dress code for the forthcoming hearing would be as follows: no pajamas, but equally no ties and jackets required, i.e. business casual. Something which there is less emphasis on now than previously. But really what I have found is presentation as a council. And themes that I've picked up are as follows: structure, extremely critical now, much more than before. You can't see the tribunal's body language as well as you could before. So it's very important to place a lot of time on the structure of your content, how you will present, what tools you will use, and whether you need to, how you can present in a more effective way. Do you need to, for example, provide the tribunal with tables or spreadsheets to aid their understanding of your submission? And that's something I've seen a lot of in the last few months, is counsel using much more PowerPoint presentations, tables, etc., with agreement of the other side and of course the tribunal as well. Another thing you will all have noticed, those of you who have been in hearings, is access to documents and files whilst you are presenting. So if you have a case, a document-heavy hearing, and you are just fumbling around your desk looking for files, and files are toppling over while you do so, it just distracts from your submissions. So it sounds obvious, but actually having a well set up environment around you really does help to focus on your submissions. I had a case 2 months ago in London where we had instructed a QC who was doing this from home. and he had a beautiful room with very nice works of art and statues around him. But when it came to his files, it was a complete mess. He couldn't find the documents, they were toppling all over him, and it really took some time before he got going, and the judges were quite irritated for a little while. So it's a very important tip. The other thing we have covered in this process is try and agree as much as you can with the other side. As much as we are in an adversarial process, arbitration is much more friendly than being in court. Use that and reach out to your colleagues on the other side. Try and agree the timings of your presentation. Try and agree the tools that you're going to use. Try and agree as much as you can. Because like you, they will be in a difficult situation. And like you, they will probably be more open to agreement than previously. So use that to your advantage. Another thing that we have all actually discovered is two things which are very close to our hearts is pets and kids. Not necessarily in that order, but we all have had instances where we have kids running into our rooms or pets going over our laptops. Most people understand that, but where possible, try and think about if you can avoid that during a hearing or your submissions. It does, of course, raise a smile for once or twice, but don't keep doing that. And some tribunal members can get irritated with repetition of that. Next, delivery is even more important now than ever before. And by that, I mean pausing really to ask if the tribunal has any questions or the court has any questions. And very important to actually look at the camera on your laptop, your computers, and not looking down at what the backgrounds of your colleagues or the judge or the tribunal members are. It's a very important point, because one thing we keep seeing is people's nostrils. And I'm sure we've all had that. It is very important to have the right height, and so that your delivery is actually within the eye line. And that's something we keep getting again and again. Next is IT help. IT is different wherever you are these days, and even within your city, every firm, every practitioner will have different IT systems. And we all have glitches from time to time, which is perfectly understandable. But if you are able to minimize the risk, if you are able to help minimize your own risk and manage that, it really does make a difference. If you have a help desk, have them on your meetings and your hearings with the permission of the tribunal members and the other side. It just eases your own stress when something goes wrong, allows the hearing to go smoothly as possible. The one big area which is challenging, I think, for all of us is witnesses and cross-examination. And there is no substitute for being in front of your witness, but we're not in that position, and then we have to use whatever tools we can to minimize the risk of witness tampering. And there are a number of protocols now available which you can sign up to and get the other side's agreement and the tribunal's agreement to use these protocols to minimize witness tampering, witness interference, and to make the whole cross-examination process as smooth as possible. And there has been some fantastic work done by organizations within Africa on putting up these sorts of protocols, and one which I can certainly recommend is the African Arbitrators Association protocol on virtual hearings. And of course, there are a number of other such protocols in place. I want to say a few words on IT platforms. We have certainly learned, and I'm sure you're all in the same category, that there is no perfect platform. We have all used different platforms, whether it's WebEx, like the one we're on Zoom, on RingCentral, on Microsoft Teams. There's any number of platforms available, and they all have their pros and their cons. Which platform you use, the critical thing is to agree on one with the other side, with the tribunal, and test it. Test it once, twice, 3 times to make sure it is as smooth as possible. And of course, on the day, you may well have glitches, but at least if you've done that homework beforehand, it avoids the tribunal getting irritated. It avoids you getting worked up and losing your train of thought when you're making your submissions. And possible, as I said earlier, have your IT help desk, if you have one, to be on the call or on the hearing, so they can again minimize and get your IT support to talk to the other side's IT support, again, to just ease the process. One thing we have come across is the issue of recording of hearings. It is something which is happening, and I would strongly recommend that is agreed with the tribunal and the other side before you record it, for obvious reasons. Turning then to a few thoughts I have on tribunal perspectives. I've sat as a member on a number of hearings in the past 3 or 4 months, and key things is preparation and planning. As tribunal members, we have really felt that those counsel who take the lead in preparation and the planning really do make a good impression. Whatever counsel can agree, again, helps the job of the tribunal members to streamline the process and to make the hearings more efficient. So that's a very important thing that I've certainly learned as a tribunal member. IT platforms and that agreed, tried and tested. Again, parties taking the lead on that makes the whole process easier for tribunal members. And then, of course, the presentation, as I mentioned earlier, making sure that delivery is effective. You're looking at the screen, you're not fumbling around for documents, you've considered how you're going to structure your submissions and pre-agreed with the other side how they may do theirs with any tools is really does make the job of the tribunal member much easier. Protocol mentioned as well. As a tribunal member, I've seen parties trying to fight over all sorts of protocols. Agree one, they're all very similar and they all have a lot of common sense in them. Don't get hung up on whether it should be your suggested protocol or the other side's suggested protocol. If you have a sensible suggestion, try and agree that, because the tribunal, it is much easier to have one protocol than have to rule on which protocol should be used. And the reason I'm using the agree a lot is that we may well be over this pandemic in a few months, and we all hope so we can return to the new norm. But the risks that we face in 3 months, in 6 months, in a year, perhaps more, is the risk of challenges to tribunal members, is the risk of challenges to awards. Because in all this trial and error that we are now facing, there is going to be a party who loses an arbitration, and that is going to come up with creative ways of challenging the award, and perhaps even challenging the arbitrators. And there could be any number of scenarios, from unfair treatment, not having had a fair opportunity, not having had enough time, perhaps witnesses may have been tampered with, and any number of variations around that, in order for the disgruntled party to try and challenge the award later down the line. So the big message is try and agree as much as you can, try and document it all, so that later on, if you happen to be the winning party, you make the process and you make the award as bulletproof as possible. And with that, I will just end with 4 or 5 top tips that I certainly have shared with my team, and as a department, this is something we've learned. Number 1, agree as much as possible between the counsel, between the tribunal members, to avoid the obvious risks that I mentioned later down the line. Number 2, document all of these agreements as much as possible, again, for the same reasons, and so there's a contemporaneous record of what it is that the parties are agreeing on an ongoing basis. Number 3, protocols are available to make your life easier. Use them, share them, and we have certainly found a number of those useful, as I mentioned earlier. Number 4, presentation and delivery. Take extra time to consider these, because there really is no substitute for a very well-structured delivery, especially in these challenging times when we're all working from home. And number 5, use common sense. We all have an abundance of it, but often we get dragged into pointless arguments and common sense goes out of the window. But use it because it will make your life easier. So with that, John, I think those are my thoughts. Happy to take questions later on. Thank you.
And yourself, excellent. Thank you very much, Kamal. You can hear me clearly?
I can.
Thank you very much. I hope everybody else can hear me. I hope everybody was able to hear you clearly. I think those were really excellent points, Kamal. You know, there was a running joke at the beginning of COVID about dress codes and having a Zoom suit. Your first point about dress code reminded me of that. Participants, there is a question and answer tool at the bottom of your screens. If you have any questions, please post them, and I will assign them to the relevant panelists so that we can get your questions answered. We will move on to the next speaker now. I think I've seen Emilia on the forum. Emilia, you are with us now?
I am, but I don't know if you can hear me.
Yes, I can hear you clearly. I'm sure all our participants can hear you. So I'll come to you then, Emilia. And if I may very quickly introduce Emilia, because I wouldn't do justice to her resume in the short introduction that I will make. But Emilia, her official title is actually Dr. Emilia Onyema. She's an academic, as well as an arbitrator. She is listed on numerous panels, the Lagos Chamber of Commerce. She's listed in the panel at Kuala Lumpur, Dubai, of course, the London Court. She's also a solicitor of the Supreme Court of England and Wales and a barrister of the Supreme Court of Nigeria. She has many, many fasts, and my head is spinning just looking at her resume. So I will let her speak to us. Emilia will be speaking to us about going virtual and implications on the triad issues of seat, jurisdiction, and enforcement. And how do we navigate the potential challenges? You will recall that Kamal mentioned in his presentation the potential for challenges being raised on the basis that the forum was a virtual forum, which might have presented certain issues, for instance, access, equality, which are all things that we emphasize in arbitration. And I hope that Emilia can address those issues to our satisfaction. So Emilia, the mic is yours now.
Thank you very much, John. Good morning from London, everybody. And my sincere apologies that WebEx would, for some strange reason, would not allow me to join you properly. So I am joining via the telephone, and I hope you can hear me. I can see John. So John, if I'm moving too fast or anything, you can wave, that's fine. I can see you. It's just that you can't see me, but you can hear me. Thank you very much for that wonderful and very kind introduction. So the task that John had set for me today is to examine some of the issues that having a virtual hearing in an international arbitration might raise. And of course, this becomes necessary because the pandemic sprung on us and most people then moved to virtual hearing. And we may not have provided for that in their rules. And so he said I should look at the impact of that on state, on the question of jurisdiction, so challenges to jurisdiction, and if it would have any impact, negative impact on the enforcement of the final award. And if I answer yes to any of these, to suggest ways of how we can navigate those sorts of challenges. And so I'm going to quickly start with this. And so the way I intend to approach this is I will deal with state, I will deal with jurisdictional challenge, I will deal with enforcement, and try to deal with those two critical questions underneath each of those issues. And so the first one on state, the way I started is that we all know that state is really important. But of course, state, in the context of having a virtual hearing, state will be thinking of the legal state, or the way the Kenyan Arbitration Act puts it is the juridical state, and then the location of the hearing. And so we have this interplay between a state, which has legal implications, and those legal implications will include the relevance of the law, the arbitration law of the seat of arbitration. And so the mandatory provisions of that law will apply, and it serves as a gap filler. So we know that. And then we know that there's something called a place of arbitration, which again we need to be careful, because Article, for example, in their text will talk about place, where when you sort of unpack that, it actually refers to the juridical seat. But the key point is that there's a difference, and what is relevant to virtual hearing is effectively that flexibility that party autonomy grants to the parties to host their arbitration wherever they want. And that's where convenience of the parties come into play. And so we have the legal state, which is what will the law and the court will give, which court should we go to if we need support, if we need assistance. Then that state, the legal state chosen by the parties, would then begin to play a role. And this is really, really important, as we would all know. And I would not speak of the case law that because Kamal and Stevenson Harwood have played major roles in some of the jurisprudence around this question, representing a couple of Nigerian parties. I shall leave it at that for now. And so that is really important. And so the next thing to pick up for me is that virtual hearing most likely will not impact much on the juridical seat if the parties have chosen a juridical seat, or how to choose a juridical seat. But of course, it will be important if you have chosen a seat that has made provisions regarding virtual hearings and how that may play out. Remember that the juridical seat would help with mandatory requirements and gap-filling provisions as well. So we would move then to what will most likely apply in the vast majority of cases, which would be the question of where to host your hearing, where to take evidence, where the tribunal meets. Then we move into the area of the place of arbitration. And the vast majority of laws allow the parties to have their hearing or their meeting anywhere they want, which is great because that is wide enough to include virtual hearings. And I'm sure we're all aware of the African Arbitration Academy protocol on virtual hearings in arbitration. And they included some annexes in that protocol. And one of those is a model arbitration clause. And even in their own model arbitration clause, they also have a provision for parties to choose the seat, which goes back to this point that we've made. There are a couple of recent decisions in the English courts on determining the law that applies to the arbitration. And the seats that the parties have chosen play a major role as an important factor in determining where is the seat of arbitration. And lest we sort of think that the seat of arbitration or determining it or determining the law that applies to it is academic, it might be useful to just sort of look at some of the cases. And there's a very popular one that everybody knows, which is Dalla. Just think of Dalla and Pakistan. It was just that question that determined whether Pakistan was party to that arbitration agreement and so liable or not. And exactly the same thing is playing out before our eyes in 2020 in some of the case law that we're currently looking at in this jurisdiction. And of course, SIT played a very important part in the famous you invest 40 million as it relates to Nigeria, and you get 6-point-something billion from the tribunal. I shall also leave it at that because we're familiar with those cases. And so, what will then be the relevance of the SIT? As it relates to enforcement, so I'm moving on to enforcement and I'll come back to jurisdictional challenges. But it looks like it's easier to just sort of flow through and move to enforcement where we are at. The legal SIT helps us understand the nationality of the award. And so if we just sort of cast our eyes back and look at the Article 1 of the New York Convention. Article 1 of the New York Convention basically tells us that the convention we apply to an award that is made in one country where you're seeking enforcement in another country. And Kamal's law firm played a major role in the court here in IPCO determining that it doesn't have to be an international award. A domestic award would fall within Article 1 of the New York Convention, and that is really, really very helpful jurisprudence. And so, which means then that if the SIT has that sort of impact, whether it is cross-border enforcement or within the jurisdiction itself, so if you look at the Kenya Arbitration Act, which follows not too closely, but closely the UNCITRAL arbitration model law, the UNCITRAL model law, and we look at Articles 34 and 36 of the UNCITRAL model law, then the question becomes that intersection between identifying the SIT and the place of hearing, virtual hearing, moving over to virtual hearing, and as it intersects with due process, with the question of whether parties have been given the UNCITRAL version is full opportunity. The Kenyan Arbitration Act talks about a fair and reasonable opportunity to present their case. And this is where I would begin to produce some, so just throw out some questions for our participants and audience to think about. So if both parties clearly say, yes, we're happy to have virtual hearing, and they sign up to any of the protocol, with or without any of the protocol, would that be a problem? Certainly not. It would not be a problem because party autonomy overrides. The parties have agreed, and the tribunal, for now, let's just put a question mark around the tribunal. If a tribunal agrees, fine as well. But what if you have a situation wherein one party is willing and able to participate in virtual hearing, and they can check off all the requirements under any of the protocols, and the other party does not feel confident that they can effectively participate in that hearing through in that virtual hearing, what should the tribunal do? Should the tribunal insist on the party who is saying, I don't want virtual hearing, not just because I want to frustrate the arbitration, but because I do not have the capacity to participate in the virtual hearing? Kamal has reeled out for us the sorts of things that we need to be thinking about. And so I'll just give you an example. Yes, it's true that I live in London, I work in London, but I've been sitting in my house and trying to figure out WebEx, trying to I've downloaded everything it's set to download, but I'm not technologically, very literate. And so I've done everything I've been asked to do. I can't still join this event the way I should properly join the event. Yes, it's true that I have IT personnel in my office, but we're all working remotely. And so they're attending to all sorts of other colleagues and all of that. If I am not able, if this was a hearing, and Kamal can join as counsel to the other side, and myself as counsel to this other side cannot participate, or as a party cannot participate, or as an arbitrator cannot participate, not because I do not wish to participate, but because the technology would not allow me, if you like, to participate. Should the arbitrator or the panel carry on with that hearing? What will be the impact of that if the tribunal continues with that hearing? And in Kenya, under your law, there's an obligation to the parties to pursue the arbitration with diligence. Would that come into play? And then the last point, before John tells me that, okay, you academics, you talk too much, is on jurisdiction. And so the Kenya Arbitration Act, like the vast majority of arbitration laws, give the power on the basis of competence to the arbitrator to determine its own jurisdiction. But on what basis can arbitrator be challenged? The jurisdiction of that arbitrator can be challenged. And so I sort of thought of a few things to throw out. So we know that we do have a generational gap in arbitration. We have young people who are savvy, tech savvy, that's their norm. They grew up that way. Some of us have had to learn. And there's some they still have secretaries that do send emails for them. And so it becomes a major concern. Can an arbitrator who is not well versed in this virtual hearing that we're talking about be challenged? And so would that be a question of a de facto inability to act? Can an arbitrator be challenged on that ground? And so those are the sorts of issues that virtual hearing pulls to light. For me, the most important point for the tribunal is, again, ensuring due process, ensuring that the parties, both sides, have been given, if it says a fair opportunity, a fair opportunity. The question that we've always asked is, what does a full opportunity mean? What does that mean? I knew I was going to participate in this hearing today. We had a dry run to be sure that everybody could log on. I was not able to log on. Kamal gave me some tips. I did everything Kamal said. I registered with WebEx. I downloaded the thing from WebEx. I was very sure. Yesterday, Sarah pursued me. Are you sure? Can you do this? Can you do that? We said we would try, but I was having meetings back to back all day. This morning, I woke up early, got dressed, ready, made up with COVID, I haven't made up since March. So I decided to make up that my brothers from Kenya and sisters would see me on the video. And then I just have been struggling to log on. If this was an arbitration, would that be me as a party failing to be diligent, to diligently pursue that arbitration? If I was an arbitrator, would that be me being not able to pursue that arbitration, my task, with diligence? If we then get an award, can that award be challenged on the basis of lack of fair hearing? And so those are the sorts of questions that I think we may want to engage with. I'm still listening. Thank you very much, John. I'm looking at your face. I can see you're about to say, okay, do you want to stop now? Thank you. I can't hear you.
John, you're on mute. John, you're on mute.
I beg your pardon. Sorry, I thought I had unmuted myself. The problems of technology. Can you hear me now?
Yes, we can.
Okay. Thank you very much, Amelia. I think that was really, really interesting. I think the issue around the juridical seat is one that is much litigated, also much misunderstood. I was presenting on a CPD on Friday to members of the Law Society of Kenya on advocacy and arbitration, and an issue arose about the juridical seat. And I think that that's one that you might need to clarify and re-clarify because there continues to be litigation around it. But Emilia, just so you put this at the back of your mind when we come to our question and answer session, this whole issue of due process and equal opportunity, does it present a new opportunity for recalcitrant parties to introduce a new form of guerrilla tactics? Because, you know, it is possible that an opponent who does not want the arbitration to proceed to agree to a virtual platform and then purport to have difficulties in access to the platform on the material day, which would seem to be a potential for a new form of guerrilla tactics, which we also need to guard against. So I just thought that was something that came to my mind. I'm sure the participants might have other questions, but something that I thought about.
Thank you.
All right, thank you. We'll come back to you, Amelia. Thank you very much. We'll move on to you now, Lawrence. As you know, Lawrence is the registrar of the Nairobi Center for International Arbitration, and it is the Nairobi Center for International Arbitration bringing you this webinar. It has given us the opportunity, really, as the center to host another conference after our really, really successful conference in at the end of February, just before the pandemic broke. And so I want to welcome Lawrence to speak to us about the preparedness of arbitral centers to facilitate arbitration in what is now the new normal. So Lawrence, I'm sure that there are many, many things you've thought about. There are many ideas that are still coming to the fore. Some of them may be constrained by resources. Some of them are things that we could do very quickly and very easily. What is it that you're doing as the center to ensure that we're prepared to be available to our users and to parties in the new normal? Thank you, Lawrence.
Thank you, John. Thank you for your kind introduction. Thank you to all the participants and the panelists for making time to join us today in this webinar. As NCIA, we are committed to the promotion of the practice of arbitration and other forms of ADR. And so this is just one of the ways in which we want to contribute to the conversations, especially with regards to the new normal. John, to come back to your question, let me use a quote by Bill Gates. He said that the advance of technology is based on making it fit so that you don't really even notice it. So that it is a part of life, really. And I use this quote because for us as centers for arbitration, the virtual space is not new or unique. Although the default position is that most parties have preferred in-person hearings, a lot of the work that goes before the hearing, some part of the back office during the hearing and after the hearing has been done on virtual platforms. So by this, we have e-filing platforms, we have e-exchange of documents, we've had partial hearings virtually, and partial hearings in person. So as it is, scanning through the rules of many of the arbitral institutions, NCIA, for example, Rule 22.5 already provides for parties to utilize the virtual space. So I would begin by saying this space really isn't unique. That said, it hasn't been the default. The default has rather been in-person, especially the hearing stage, in-person hearing. And a lot of that has to do with the concerns that Kamal has raised, the concerns that Emilia has raised, and perhaps also the concerns that tribunals themselves would have. We have been groomed, grown in a culture where the tribunal wants to see the witnesses, wants to perceive the demeanor of the witnesses. And because of those advantages of in-person hearings, the default position really has been, for the hearing stage at least, to have in-person hearing. So over time, we have grown to adapt virtual platforms to enable parties either to file documents, to exchange documents, to make payments, to communicate between the tribunal and each other, and to facilitate the partial hearings that have been held virtually. What we now are faced with is the question, is there going to be an inversion of the default position? Is a virtual platform going to take over the space that has previously been occupied by in-person hearing? And that is a question that perhaps we will have to contend with should this pandemic be behind us. But it has also raised the concern to us as centers that maybe this is just the emergence of a new normal, so that whether or not we are faced by a situation as we are in now that has forced us to engage more in the virtual space, we may want to take the advantages of having the virtual platform available to parties. And for this, where I sit, there are four main concerns. One of them is accessibility. Our party is going to be accessed to the same platform in the same level of utility and in different locations at the same time. So you have the question of time differences between the different geographical locations. So accessibility will be one major point to consider. The second point, and we could expound on this, is affordability. A lot of the IT capability, at least on the continent, is concentrated within the urban centers. How accessible is this technology to areas beyond the urban centers? And that could be the story, whichever jurisdiction you go across the globe, not really just in Africa. Then the question of availability. So there's access, there's affordability, and there's availability. For most parties, apart from corporations who will have a history of dispute resolution, they may never engage in dispute beyond that one arbitration they had, two arbitrations or the like. So they're unlikely to invest heavily on infrastructure that allows for them, whenever involved in a dispute, to participate effectively. So availability. And then, of course, the question of adaptability. Technology, as Kamal has pointed out, and as Amelia has pointed out, faces the question of, is it compatible? So we have, as you have pointed out again, various platforms that we all are trying to see the advantages and disadvantages of. And so these are questions that now as centers we are having to address, and some of the ways in which we proposing to at least reduce the nuances that arise as we consider these 4 A's is again 3 areas. One, the legal questions. Amelia has alluded to this. Can the parties actually participate in a virtual platform and have an outcome that will be recognized and enforceable? And so if you think about the Africa Virtual Hearing Protocol, the Seoul Protocol on video conferencing, these are some of the attempts that centers have come up with to at least address the questions that may be raising legal challenges for parties after the arbitration has been concluded. Apart from the legal question, then there's a technical aspect of it. As centers, really, we are the focal point where the parties and the tribunals meet. And so it is really our business to invest in ensuring that parties and tribunals are able to conduct their business without hindrance. So we are then called upon to invest in infrastructure so that even for that party who may not have an archive of cases, they can access our facilities as and when they require them. If it is a problem of multiple locations, again, as centers, we have had a history of collaboration with each other. So we enter into protocols of understanding so that whether or not you're using the rules, for instance, of NCIA, you can access its facilities for video conferencing and connectivity to be able to conduct an arbitration that is LCIA based, for instance. And then the third point is user support. I think Amelia has well pointed out, beyond availing this technology, there is a need then to support the user to ensure that that day that is reserved for hearing does not necessarily turn out to be an aborted hearing simply because one or the other party could not access or participate in the hearing. There's a cost element to it. So the legal questions, the technical preparedness, and user support to ensure that these platforms eventually connect the parties and the tribunals so that they can conduct their businesses. We will come to these points a little bit later.
Brilliant. Thank you very much, Lawrence. I know you've said we'll come to these points a little bit later, but there's a question that immediately comes to mind, and that arises from Amelia's comment about the challenges that she has had with accessing this platform. And you know, in the last 3 months, I have been on, I don't know, 5, 6 different platforms. I've been on Zoom. My own firm uses Microsoft Teams. I have been on GoToMeeting. I've been on Google Meet. And now there's Cisco WebEx. How do arbitral centers decide what is the best equipment, what is the best forum to host these virtual meetings? Is it a cost consideration? Is it a security consideration? Is it popularity? How is this decision made? Because I think it is relevant to our users in the sense that when you're hosting different parties, they come at you and they are required to engage on the platform that you give them. Are you open to parties saying, no, we would rather use a different platform? What are the considerations?
Thank you, John. Yes, it is true. We use different platforms for different purposes. When it comes to determining what platform to apply, many considerations will be given thought. And so one of the points you pointed there, of course, is security. The other one could be, I pointed out the four A's: access, affordability, availability, and adaptability. So I think I would, at the beginning, first point out that from experience, none of these platforms that is now available is, you could say, without its own advantages and disadvantages. At the end of the day, what the institution would have to determine is these 4 A's. Given arbitration as it is, places a high premium on confidentiality. The question of exchange of information, whether that be audio or in document form, plays a very big role in the entire ecosystem of arbitration. And so when you take into account the security features of a platform, for the sake of securing the information that is passing on between parties, for the sake of ensuring that access is regulated, is controlled, parties who are participating in a proceeding or have access to the proceeding. I think initially when COVID came in, there was one platform where, which was easily accessible, but the challenges that came up was the proneness of the platform to intrusion. Not just parties who shouldn't be in the arbitration, but parties who are just mischievous in the virtual space. So some of the responses that as arbitral centers we have had to immediately kick in to address is a question of security, the encryption features of the platform. Because if it comes to a hearing, you really do not have the luxury of chancing. And so many of these decisions will center on the use. Again, looking to longevity, it is unlikely that an institution will be moving from one platform to another. And so there will be a need to address a holistic view of the use to which the platform will be made, right from the pre-hearing stage, which is the documentation stage, the hearing stage, and after the hearing, to ensure especially security, confidentiality of the proceedings and documents is protected. So there are many conversations that will have to be considered. I think key of them is security and confidentiality of the exchanges, communication and documentation.
Brilliant. Thank you very much, Lawrence. Thank you for that. Now, I have to apologize for the fact that we have been unable to reach Professor Githu Muigai. We were really, really looking forward to having him as one of our panelists. It appears that he has had some challenges with connecting on this platform. We are still hoping that he will join at some point, but we have a stellar panel, so I'm sure that they will be equal to the task. So Kamal, I will ask you to address one of the aspects that we were going to ask Prof to address, if you don't mind. As a seasoned arbitrator yourself, I would like to ask you to question, how will you as an arbitrator retain control of the arbitration room on a virtual platform? How do you ensure that the interaction between the parties continue to be one that is on the same footing as what you would expect on a physical hearing? How do you interact with technology? How do you equip you to be familiar with the technology so you can control the presentation of evidence and give every side an equal opportunity to present their case?
Sure, thank you, John. So we have a number of discussions on various panels that I have sat on in the last 3 or 4 months, and just taking a few common themes that have emerged is as follows. Much more of an increased discussion behind the scenes in terms of the tribunal members themselves. So where you have a panel of 3, I've certainly found that to be in this current pandemic a real blessing in disguise, because each of us can share our own experiences with other tribunal that we sit on, as well as perhaps you sit in a law firm, the experience of the law firm and their arbitration team. So the sharing of experiences certainly helped me personally to deal with situations and parties who are clearly playing guerrilla tactics. One thing I have also found is that communication that allows us to tailor our communication with the parties to ask them very probing questions on their own thoughts and views on how they would like certain things done. And the point of that is to try and keep them on the straight and narrow when it comes to their own clients, asking them to play some underhand tactics. So, for example, where we have agreed a platform, whether it's Zoom or Teams, we would ask the parties' IT experts to liaise and report back to us on what communications they have had, what preparations they have made, to make sure that they are able to participate on the day. And then to take it a step further, which sure, it creates more admin burden for the parties, but it protects the tribunal and ultimately any award from challenge. So as a reserve, we would then ask them to come up with a backup plan. And that may be, let's say, having a hearing on Microsoft Teams. But if that doesn't work, to confirm that they have tried and tested Zoom. And if that fails, to make sure that the parties are in agreement that if one party can dial in and the other one cannot, to just have a simple old-fashioned audio dial-in system. That works very well for case management conferences and situations where you don't need live evidence. With live evidence, it is more tricky because you have had to agree a protocol for the examination of witnesses and their cross-examination as well. Experts, of course, fall into the similar category where you do need to see them and hear them. That's more tricky, but then having the ability to sign up to protocols means, again, you've got a set of rules that everyone is abiding by. You've tried and you've tested the platform. You've tried and tested the ability of the witnesses to remain independent and for the rooms not to be tampered with. So it has been a bit of trial and error, but there are some obvious things you can do as a tribunal member to avoid the usual tactics. So if you have a situation, for example, where on the day the party says, very sorry, we can't get a video connection, we don't think the tribunal should proceed today because we only have audio, it would not be fair on our client or ourselves if the tribunal can't see us. The backup is, okay, that's fine, let's go to plan B, which is maybe Zoom, or plan C, which is pre-agreed, which is let's have an audio call. So you're trying to minimize the usual underhand tactics which parties use or their lawyers use to set up a challenge for later. And I think that has certainly helped us to minimize it, because parties who are planning that sort of underhand tactics are taken by surprise when it is a tribunal in the driving seat saying, well, have you done this? Have you considered that? What about this? And what about that? So the point is that tribunal members have to work harder, think smarter, and be much more engaged and share their experiences behind the scenes to avoid those sorts of obvious scenarios. We can't cater for every situation, but whatever we can cater for, I think it helps if we work as a team. And if you're a sole arbitrator, share experiences with colleagues without divulging confidential information. Get their feedback as well. And there's a lot of help out there if you ask for it. And we're all sitting at home, and so asking each other what is your experience on X, Y, and Z certainly has helped me and us as a team to make sure that arbitrations have run smoothly, and if there are challenges, to make sure that we try and agree that and address that beforehand as well. In terms of platforms, the comments which Lawrence made and Emilia made, we have been in hearings in London Commercial Court, for example, which insisted on Skype for Business. And at the end of that half-day hearing, one of the judges ended it. He thought he was on mute, and he was talking to someone saying, "Well, we escaped that by the skin of our teeth." And the point he made was a valid one. It was a horrendous experience because despite the party's suggestions, they insisted on Skype for Business. And it's not a criticism of Skype for Business, but it just meant that they didn't really take into account what the parties had suggested, insisted on a platform which wasn't very tried and tested in the early days. It may well be absolutely fine now, but it's a learning process for everyone. And we're all learning, no matter where you are in the world. No one's got it right, no one's got it perfect, but the point is collaborate and make sure you together try and find a solution. So those are some of my thoughts.
Thank you very much. Thank you. I see some questions coming up. I've seen an interesting question from Ibrahim Godofa, a young arbitrator, asking about a decision of the Supreme Court of Singapore. Perhaps, Emilia, are you familiar with that decision? Emilia, are you still with us?
Sorry, yes, I was on mute. Which of the decisions?
There's a question about there was a question about the decision of the Singapore court, the Supreme Court of Singapore in China Machine Energy versus Jaguar Energy. It's a justice. It was a natural justice challenge on the basis that some of the procedural directions issued by the arbitration tribunal breached the respondent's right to natural justice. There's a question around that and whether parties' agreement to participate in virtual hearings should be adjusted to that decision. Is it something that you feel able to address, Kamal or Lawrence?
Sure, I can just, from the practical point of view, this case underlines the point I made earlier, is that what are we going to see in 6 months, in 9 months, in 12 months? Parties who lose will come up with all sorts of creative arguments to the courts, who will be dealing with the enforcement applications and the challenges. And I think this is going to be a very subjective approach. Courts in England, for example, where I practice by and large, will take a very, very clinical view of this. If you have agreed a process, by and large, you have abided by it. If a party then rocks up and says, well, we couldn't get onto the platform or the internet kept cutting, provided that they were heard and the tribunal gave them a reasonable opportunity, the English court's not going to sit there and say, well, we are going to allow this challenge. It takes a very minimalist, non-interventionist approach to challenges, and it's extremely difficult to succeed in challenges like this unless there are very, very strong grounds for doing so. Now, in other countries where the judiciary may well have not been equipped with modern technology or not had a lot of virtual hearing experience, and perhaps are more interventionist in the arbitration challenges process, may take a different view. They may well sympathize with challenges such as this and give them the benefit of doubt. And all that's going to lead to is further appeals to the Court of Appeal, Supreme Court, further up. And so I think this case highlights an issue which we will see in the coming months and years to come, and it will only lead to further enforcement. Now, as we know, enforcement of arbitration awards these days takes a life of its own. Emilia mentioned some of the cases that we have been involved with, which have taken a decade or more. And where there's a lot of money involved, parties are going to fight very hard. And so I think this situation that we're in is only going to add to the enforcement battle later on down the line.
John, can I just add a little bit to what Kamal has said, and just
Certainly.
to raise the point, to raise the point about waiver, which also played a role in that in the outcome of that case, and it's just for parties to be aware that some of these questions can fall within the waiver provisions in arbitration rules and laws. And the key point, the key takeaway is that parties need to be proactive and to raise the concern of due process or lack of due process immediately with the tribunal. And that is really, really important as well. And so if we have more laws now requiring parties, and as I have mentioned, the Kenyan law is very, very clear on that the parties would need to be proactive and to diligently pursue that arbitration. So you can't be playing tactics. And that goes to the question you had raised to me about how we weigh both the opportunity for guerrilla tactics and due process. Where do you draw the line? And of course, it's something that we need to deal with on a case-by-case basis. But the danger is that you then fall back to the old position of a lot would then depend on the court you are before. And as Kamal has said, the courts here are very heavily pro-arbitration. So it will take a lot for them to set aside an award, and the Singapore courts are the same. But what if you go to jurisdictions where the courts have not really bought very much into this idea of arbitration, or you have a judge who does not fully appreciate the demarcation between arbitration and litigation, and reads it and says and feels that, well, if I was the one making this decision, I would make a different decision, and on that basis sets aside that award. And so again, that would then of course have a major impact on cost and time and all of that, and the reputation of the jurisdiction and the process. And so it's just something to keep in view. Let's remember that the parties went to arbitration. One of the major reasons is because they didn't want to go to the courts. And so let's not get them back into the courts if it's not necessary.
Thank you. Thank you very much, Amelia. That leads me to another question, which I would like to pose to you, Lawrence. As you know, since the onset of the pandemic, the courts have really moved to a virtual platform. We now have mentions, directions, some submissions being conducted online. I haven't had the opportunity to conduct a hearing on the virtual platform, but I'm very sure that is only a matter of time. As you know, yesterday, the Chief Justice also launched the e-platform for our court system. And this will start off in Nairobi. I think all the courts in Nairobi, at least all the Court of Appeal and the Supreme Court will utilize this platform, as the Environment and Land Court and the Employment Court and the Anti-Corruption Court. Now, from your perspective as an arbitral institution, do you think that this step, which has pushed Kenya into the 21st century, does it make Kenya a more attractive seat? Do you think that it gives judges a better ability to understand the challenges of virtual platforms and therefore have a better ability to deal with challenges for enforcement and recognition which might come to them arising from arbitral decisions handed down, whether domestic or international? What is your view of this development?
John, before I answer your question, let me go back to the question you just raised earlier regarding the China machine case.
Yes.
I think there's a point that Kamal had raised initially when he made his introductory presentation. The case actually does highlight the need for parties going forward to address the question of virtual hearing. A lot of this has been left to ad hoc agreements, either before or during the arbitration. And I think what COVID has done is that it has highlighted, especially for those transaction lawyers, when they revert to the dispute resolution clause, either to consider the rules that they are adopting. So do the rules of the institution comprehensively deal with the question of virtual hearing? Are they going to adopt a protocol that will comprehensively deal with virtual hearing? Or at the initial stages, the arbitration is commencing, will the whole question of whether or not to anchor either the hearing in whole or partially be done virtually? Because when you consider the facts of the case, a lot of it centered on the attempt by one of the parties to use delay tactics, guerrilla tactics, basically to frustrate the process of the case. So I think the point to learn from this case is we can no longer leave the question of virtual hearing to be decided maybe at the order for direction number 1 or somewhere between the course of the proceedings. But then back to the question you posed. I think for me, this comes as a blessing. It narrows the distance between litigation and arbitration and ADR significantly. Whereas these other processes have embraced or maybe advanced to embrace technological procedures, the courts have lagged behind for some time, and that now they have also embraced the idea that even litigation itself can be conducted virtually, has in some way reduced the difference that the distance between litigation and these other processes, which breeds a bit of harmony. That said, it also gives, in my view, an add-on when parties are considering the question of choice of seat. One of the things that may, from this point henceforth, be a key factor is the readiness of that jurisdiction to host the litigation part of, if you like, post-arbitration proceedings virtually, so that you're not encumbered once you're out of the arbitration process and now into the enforcement process to have to revert back to the in-person space. Even during the arbitration process, when you want court support, it will now be easier for the court to appreciate having proceedings to support arbitration virtually, as opposed to parties running to in-person hearing when they want court support and then reverting back to the virtual space. So what it has done is basically reduce this curtain, literally tear apart the curtain that has existed between court procedures, arbitration, and other ADR processes. So it will be easier, in my view, now for the courts to appreciate, one, the challenges, but also the availability, accessibility of these processes to parties. So that, for instance, the question that arose in China Machine will not be a big issue. Courts will have themselves encountered such tactics by parties in litigation and insist on parties coming to court in good faith as it is will be required in arbitration. So I think it is a good thing for arbitration that now courts are also embracing this new norm.
John, could I say something on the back of that?
Certainly, Kamal.
The point Lawrence has made is an important one. Sitting in Mombasa now and putting my hat on as a Kenyan, and bearing in mind where I practice, which is in London. I think we here in Kenya and the rest of Africa really are in a unique position now to take advantage of our arbitration centers. The in the way that we led the technology when it came to tools like M-Pesa or jumping the landlines and going straight on to mobile phones, if the centers here, and I think NCI is a good example, take the lead in amending the rules and really promoting and embracing virtual hearings, it will address the common problems that we all face by our clients. How much is it going to cost? How long will it take? And what are the courts going to be like when it comes to enforcement? Let's take the lead now and really get an early mover advantage by amending our rules, having these sorts of sessions and really engaging with the judiciary. Already we know about the online filing system that we've embraced here in Kenya. Those are the sorts of things actually which are infrastructure, as I call them, the infrastructure of a hub like Kenya, which will give us the advantage when the world slowly gets back to normal and investors are now turning to where they should put their money and what issues they will face later on down the line. Because if you have that infrastructure in place and you're investing in it now, that's the sort of advantage which will give us as a hub and as a center of arbitration. And these common issues that we get, well, do we need to bring in, do we need to travel, and how much is it going? You don't need to travel. You can do it virtually. The rules say so. Parties have signed up to it. So I'm just saying, from a 6 months, 9 months later point of view, we have a real advantage here and a unique opportunity. So let's embrace it and make these changes to make Kenya a leader in the region, because not everyone is doing it. Not everyone will either.
Can I quickly just support that and say that I'm sure, I hope you're all aware that we released 2020 arbitration survey report, the Arbitration in Africa survey report, yes, on the 30th of June, and we had ranked arbitral centers and states. And one of the things that came through, and we note that, is that arbitration practitioners on the continent are very technologically aware, and they want to be able to use technology as has already been described. I think that arbitral centers on the continent can aid and can support that and can actually earn an income from allowing their centers to be used for different hearings and all of that. You know, it's just like having, providing those sorts of services for arbitrations, either ad hoc or under other rules in your center. And I think that is really important. Of course, the other side of the coin is that we're not the only ones taking advantage of the new phase of life, because I think we've moved on. Is a new evolution, if you permit me to say that. And so the key thing is all institutions are doing the same. And so the key question then becomes: is this a period where you would have the ICCs and the LCIAs standing up to say, continue to choose us, we have more experience, and you don't need to come to Paris, you don't need to come to London to have your arbitration, because it can be done virtually. And so there is a lot of marketing to be done and a lot of publicity to be done to ensure that we retain arbitrations linked to the continent, on the continent, and saying that you know, for me, what I really want to hear is that you can appoint a South African as your arbitrator or a Tunisian, and they don't need to fly all the way to Nairobi if that's where the parties are based. I think that is really important for us to also consider and think about.
Thank you, Amelia. I think that's a really interesting intervention, because it really leads me to I was thinking about as you were speaking. which is the issue. I remember attending a conference a couple of years ago where one of the topics was the question, is the court a place or a service? And I think we have really moved into that. And so the question that I now ask is the same with our arbitral institutions, because, you know, a lot of times when we go on these road shows and we talk about our various arbitral institutions, we talk about access, we talk about location, we talk about our infrastructure, our hearing rooms, and so on. Is the way we position our arbitral centers going to change from saying this is where we are located to this is what we are able to offer in terms of accessibility, in terms of document management, in terms of our panel, and so on? Lawrence, is this something you want to speak to?
John, I couldn't agree with you more. I did mention earlier, we will have to grapple with the question, is the default position shifting? Will the default position now be virtual? And certainly, if the answer to that question is in the affirmative, then clearly the narrative has to change. The test, the assessment of the ability of a center, in many ways in the past has been also linked to the physical facilities that a center has. And centers have gone to a great deal to invest in physical infrastructure, meaning the buildings where hearings can take place. If the virtual space does overtake the in-person space as a default, then clearly the narrative must change. Having said that, it is unlikely that it will entirely remove the necessity of the in-person hearing space. And there are various reasons, because sometimes even the virtual space may need the physical infrastructure to support it. And so take the example of that corporation, which may not have an archive of cases. They only use this service once in the lifetime of a general counsel. They are unlikely to want to go to a large extent to invest in those kind of facilities. There are questions about the arbitrator himself or herself being able to conduct an entire hearing, maybe from the office, maybe from the home, because of, again, the access, affordability, adaptability of the systems. So we will still be seeing the customer moving to the center to access the virtual facilities of the center to conduct their hearing. So the narrative might change to, yes, we can conduct an entire process from A to Z on the virtual space. And yes, we are also available for those who are unable, for various reasons of asymmetry, to host that kind of a process, to access the centers for the purpose of conducting virtual hearing. Maybe what might change is the extent of investment in the physical infrastructure vis-a-vis the virtual infrastructure.
Yeah, can I just add to that, John? Just say the issue of physical infrastructure, of course, will be considered by a number of the centers. And the point Lawrence makes is a valid one. It is important to retain that and to maintain that, because what we're seeing now is a hybrid situation. As countries are opening up and offices are opening up, there are some judges or rather arbitrators who want to have the environment of a center. So what may happen is the tribunal may still come into the NCIS premises, use the physical infrastructure, but then perhaps have virtual hearings with parties not necessarily having to travel in. And again, if you are promoting that sort of a service actively, people just end up thinking differently. And there's a lot to be said for promoting these sorts of scenarios with the ultimate user because not everyone will be familiar with the difference between a hybrid arbitration or the difference between having a seat somewhere and an actual hearing in another place to save time and cost. So I think those are the sorts of things that we can be doing to promote ourselves here as a center.
Okay.
John, is it okay for me to just sort of explore some of this a little?
Certainly, Amelia. I was going to ask you a question. Please intervene.
Okay. I just want to sort of say that even if we look at universities that are heavily localized, and so we make a lot of our physical infrastructure, our environment where we are, our footprint. The key thing to note is that we need to rethink the way we offer our services. And then this whole idea of a global university, if you think about it, I think that for me, I think that's where African centers need to begin to think what they need to begin to think about. It's that pulling together of their resources and supporting one another to up their game, so that it actually becomes properly a business model, such that if you have a dispute and the parties want to meet anywhere, they can have access to comparable services to meet wherever on the continent that they need to meet. I think it's thinking a little bit more boldly and looking at provisions in the round and asking ourselves, having accepted that clearly arbitral centers run a business, the question then becomes, what is the product that they are producing? What's their product, and what is it that they're selling, and how do we harness all of that in the spirit of promoting the continent, not just the region, because we have regional big players. We know that. But how would the Nairobi Center for International Arbitration link up with the Cairo Regional Center, link up with Arbitration Foundation of Southern Africa, link up with the Lagos Court of Arbitration, link up with, we have strategic centers across the continent that can market and pull that, carry the weight of what we need on arbitration in Africa. So it's just to throw that out there to say that I think there's a lot that we can do with this.
Okay, thank you very much, Amelia. And since I still have you on, Amelia, there's a question that has arisen which relates to arbitral institutions' handling and management and presentation of evidence through digital platforms. But I want to tie that up with a different question, which is the question of the whole assessment of the credibility of witnesses in a virtual hearing. How do you deal with that as an arbitrator? But as an arbitrator as well, and perhaps also as counsel, how do you deal with the challenges posed by having your witnesses in different locations join the hearing? How do you manage the presentation of their evidence? And how can an arbitral institution, through a centralized system, enable you to present your evidence through a digital platform? How would you suggest that we work this?
Okay, I can speak from my own experience, but as an arbitrator, where we've had, we were having a hearing in Abu Dhabi. We were physically in Abu Dhabi, and one of the witnesses was in London, but it was one of the major firms in London, and he was giving his evidence through virtually. He was giving his evidence virtually. And so for us, we had the documents and all of that. We had counsel in the room with us. And it was seamless. It was seamless. But of course, a lot depends on the system, the technology, and what the evidence is about. So where you're going to, and I'm sure Kamal can speak more from the council perspective. I don't access council at all anymore, and so Kamal can speak from council perspective. But for me, at least from that experience, it was seamless. It was straightforward. All the protocols had been in place. We knew what time he needed to be there. He knew how much time he had and all of that. So if I'm going to speak from the tribunal viewpoint, it would be how prepared the panel was. And so because the panel had read the documentation and we had clarity with what questions we needed and what we were looking for, the clarifications we were looking for, it was quite straightforward. And we're quite lucky because the technology was seamless. It worked. It was almost like being in the same room with the guy. But don't forget that this was just one witness. And we didn't have the full gamut of cross-examination, all of that. There were straightforward questions that he had to answer. But I have been in webinars where we had, there was an IBA webinar that one of the presenters was in Nigeria. And it was a Zoom thing, but she kept cutting out, the internet just was not stable. So in my office, we use MS Teams. So in my home here with MS Teams, also sometimes my internet is unstable. And so people freeze or they can't hear me or I can't hear them. And, that distorts the flow of the evidence. I think a lot goes back to that, to what Kamal and Lawrence have already said about getting the technology right, making sure that there is support on hand to just deal with whatever problems that may arise. But my own experience has been it worked really well. But I've also heard some horror stories, but I don't have any experience of that. And the only thing I can say is that from the various stories I have heard, the key thing is if the witness is being prepared and, prepared in the sense of properly prepared, not to tell them to lie or to tell them to say what didn't happen, then they should be able to present their evidence. But, prepared in the sense of helping them understand what would be expected of them, what it is about, so that they can relax and just tell the story the way they know it. It is usually, it then works. But if a witness is being primed to sort of color the facts, then it becomes a problem. It might become a huge problem in addition to the technology, of course. So I don't know if Kamal wants to speak to this question from the perspective of counsel.
Sure. Yeah, thanks, Amelia. So from the point of counsel is we have been in cases where everything's gone very well, the technology works, witnesses are truthful and honest, and that all goes well. Equally, we've had nightmare scenarios where it's a combination of having a shifty witness in a dubious environment, not in a environment which is controllable, and the technology also not being great. So there's a few things we try and control. One is the environment itself. Asking a witness to go into an independent environment, it may be a law firm, it may be a hearing center, it may be something else, in a professional environment which has a good room, good soundproofing, good lighting, and no ability for someone else to be sitting across the board or passing notes from glass walls and all the rest of it. All of these things can happen, and we've seen it. So to control the environment as much as you can. If you are able to agree, have an independent say, a lawyer from the law firm with no connection with the witness sitting in the room, verify that nothing was tampered, no notes were passed, the witness had no technology to enable him or her to receive messages and so on. And so all of this goes to the preparation and really thinking it through, where the witness is located, what services are available, do you have the resources to ask that witness, can that witness travel to a law firm or wherever that may be in a controlled environment? And the more you think about this up front, and the more you agree with the other side, and the more you agree with the tribunal or the judge, you're just minimizing the risk, because that's what it's all about, is minimizing the risk. Ultimately, at the end of the day, if you have a witness who really is shifty, that hopefully comes through to the tribunal, who can weigh up the evidence. They can discard it, or they can give it appropriate weighting. That's all we can do as counsel and as arbitrators, is control as much of it we can. The rest is up to those who are adjudicating to weigh up the evidence. They can just kick it out if they feel the witness is not complying by the usual rules.
Okay, interesting. I think those are challenges that we will have to grapple with, and which brings me actually to the question, Lawrence. Is the Nairobi Center formulating protocols for virtual hearings? When will we see these protocols? And can you give us a teaser as to what you think might go into these protocols?
Thank you, John. Yes, as I initially mentioned, in our rules, Rule 22 already allows parties to have either a hybrid, virtual and in-person hearing, or take the entire hearing virtually with the consent of the parties and the tribunal. But what we have then since done under the third point of what, as an arbitral center, we think we can contribute going forward, the user support, is to come up with a protocol, not entirely new from what you've seen, especially the African virtual hearing protocol. What you realize, just like we have said with this technology, no one protocol that is at least available out there will address the unique circumstances that the various centers will find themselves in. So if I could think of centers on the continent, there will be certain challenges that are unique to us that may not be the same with a center in Europe or in Asia. And so rather than just adapt what is out there, we have had to look at the various protocols, right from the Seoul protocol video conferencing to our very own Africa Academy protocol on virtual hearing. And so in the coming month, that is August, we are likely to have our own guideline and protocol for parties to use alongside our rules when they are conducting virtual hearings. That is in the short term. Of course, eventually, as you said, this narrative might very well shift. And so with the paradigm shifting to the virtual space becoming more the default, a holistic review of the rules will then follow, which will then anchor either an opt-in, an opt-out, or just basically provide a more expansive provision for virtual hearing in the NCIA rule. One thing I can assure you is that we do not see a reversal of the change that we are seeing now. The virtual space, which has been in the background, whether or not the centers adapt rules and mechanisms to facilitate it, is the future. And so we cannot but just adapt to providing that support to users, whether by rules, regulation, and the infrastructure to allow for them to be able to access the service henceforth. So yes, in the coming month, you will have guidelines, you will have a protocol that will be adaptable to the rules of arbitration to assist parties conduct either fully or hybrid virtual and in-person hearing.
Okay, thank you. That's very useful. Let me move on to something slightly different, Kamal, which is how, I mean, Lawrence has said we do not see us going backwards. So the virtual space will become more and more prominent. Now we are having this webinar on the virtual space. You're sitting in Mombasa. Lawrence is in his office in Nairobi. Emilia is in her apartment in London. I am in my study at home. You know, our ability to interact as an arbitration community was to a significant extent built on attending conferences, interacting. I mean, I first met Emilia at a conference, and thereafter we developed a relationship and gotten to know each other. I know that I met you, Kamal, separately, but conferences enabled us to interact and therefore to be able to have confidence when referring either parties or opinions to each other and so on. How do you see this, this panning out? Do you think that we are now confined to the virtual space, or will I have the opportunity to again soon?
That's a very good question, because you cannot email a handshake, and you can't really. It's not the same having a Tusker together on a video call, is it?
No.
I think we all accept that we're all desperate to meet, whether it's in a meeting or a conference, or having a drink or a meal together, because that's how humans form relationships. That's how we meet new people and build on relationships. And that's how we resolve our differences face to face, for the most part. But I think what we also have to accept is this home working, home learning has taught us is the value of that human interaction. But we don't need to be doing it every day. We don't need to be on planes twice a week, once a month, going to far-flung places, spending valuable money, time, and burning a lot of jet fuel. One of the events early on I did was for the LCIA, and they did an event called LCIA on Zoom, Tilney on Zoom. They have this biannual meeting at a very nice place in UK, where we all meet and talk about different issues. One of the questions there was is this the start of greener arbitration? And I think it is. We will think twice before we sign up to every single conference to attend. We will think about the cost. We will think about the opportunity cost to us and our livelihoods and our spaces. So I think it'll make us focus on what we should attend and why. Whether we as a community can get a bit greener by having less events, but more focused events and more valuable opportunities to actually meet and interact. And I think, again, this is where, Lawrence, you and your team can take a lead on reaching out to these other organizations who are organizing conferences. Let's pull together. Let's brand these conferences NCIA in participation with X or in partnership with Y, and have more high quality events in hubs which are easy to get in and out of, rather than having events all over the place and just stretching everyone's resources. And actually, what is it amount to at the end of the day is just a lot of money spent on planes. So I think we will refocus our efforts, and I think the organizations, the centers should be collaborating more, because we as the attendees can only attend so many, and we're not going to attend that many. I think we will really shift our the way in which we're spending our budgets, the way in which we're spending our time, how we interact with the arbitration community will change, I think, probably for the better.
John, can I come into that question?
I was going to ask you a perspective, Emilia.
Okay, so I fully agree, but I think we would attend more conferences. Because I think what this has shown is that we do not have to be physically in the room to attend a conference. And so we can't have conferences wherein people, it's an investment. It's for people to determine how many conferences do I want to physically engage with or participate in each year and identify those. But what it means for me is that our conferences can be opened up to many more people. And so we will have people in the room, and there would be physical networking, but there would be people who, if they can't fly in and they can't attend physically, they can attend virtually. All it means is that the networking bit they might miss, but which is fine, maybe because they don't need it, but then at least it's greener. It would save them some money and all of that. But it would open up our conferences to many more people. If we just think about the number of webinars we've all had to either participate in or speak at, but that opportunity, because conferences is also an opportunity to learn and to share recent, ideas, to engage. Apart from the networking side of things, it gives us, I think it opens up the space to many more people. And speaking from the perspective of the continent, we know that cost is really important. It factors into conference attendance and things like that, especially for younger colleagues. Now, the space opens up. They can learn, they can participate, they can speak. And for people speaking about Europe and other places that seem to prefer to keep people away from coming into their countries to spend their money, visas. You don't need to stress stress yourself that you can't get a visa, so you can't participate, but you can participate. So I think that there are gains on both sides. I think the positives outweigh the negatives. So I agree with what Kama has said, just to add a little bit to it.
Okay, so what you're saying is that you see a hybrid of attendees, so to speak, those who are happy to come physically and those who can then join on a virtual platform.
Yes, and for us, for our conferences, that's the way we intend to, we will proceed. On that, we have to give people that opportunity to fully participate. And again, because our own vision is not exclusion but inclusion. So that's the way we would go.
Excellent. Lawrence, is that something you've thought about? Do you have the same perspective?
Well, John, we had a taste of it in Mombasa. I recall a couple of the panelists did join us virtually. We did have an entire session on IT, more like a premonition of what was coming. So we have already integrated the reality that the networking space also will inevitably be influenced by this virtual platform. So I do foresee this providing a space for centers to collaborate in hosting these events. And this is where the hybrid nature of it comes in. Some participants could be in my center here, others would be in Kigali, others in Cairo, and we could have a virtual space conference based in different locations across the continent and beyond. So yes, there will be that room for physical conferencing, as and when it is really necessary. I agree with Kamal. It will be a question of, is it necessary? But again, I also agree with Emilia. This platform provides greater accessibility. So for those people who would never meet, and many people on the continent are disadvantaged purely on that ground. So it has opened the whole scope of other people who would otherwise not have participated in conferences effectively. So I do agree, yes, that is the way we likely will be going.
Brilliant. Thank you very much. It has been very, very interesting interacting with you. Before our session this afternoon, do you have any closing remarks that you wish to make, Emilia? Start.
I think to just say a huge thank you. Thank you to the Nairobi Center for International Arbitration. They are my brothers from another mother, as we say in Nigeria. To say thank you to John, thank you to Lawrence, thank you to Kamal, thank you to Sarah and to all the organizers. And thank you to the participants. Thank you for listening to us. We've thrown out various ideas. It's for us to engage and see how we can support each other. For me, the only thing I will plug quickly, hopefully, I know that Lawrence has a copy because the Nairobi Center for International Arbitration featured in the report we've just published. Please read the report. Please give us your feedback. Please, circulate the report. We want to celebrate African arbitral centers and our faith, and that is really, really important. So thank you very much for the opportunity.
Thank you very much, Emilia. It was lovely hearing from you, even though I couldn't see you, but I'm sure I will have the opportunity very, very soon. Kamal, any closing remarks from you?
Sure, thank you. Similarly, thanks very much. It's been really enjoyable, and I think NCAA is taking the lead. Should continue to do so to have regular webinars on very topical issues, with perhaps one variation that I've seen in one or two other webinars is to ask the participants beforehand to submit some questions, and then give them the opportunity to expand on that question so that it's more interactive, and I think that helps the learning and sharing part of it. But well done, and thank you again.
Thank you very much, Kamal. We will certainly take your point, and I'm sure that we will improve on this next time. Lawrence is actually our host. What are your closing remarks?
Well, thank you, John. Thank you to my very able co-panelists, Emilia. It would be remiss of me not to recognize your efforts towards building a harmonious space and field for arbitration in Africa. Thank you for agreeing to join us today. To Kamal, our friend, really our son, thank you for your kind comments. We, of course, were having the first one, and we will take on board the good suggestions that we can build on in the next webinars. We are looking to have one in July, so look out for the next webinar, where we will continue to build on this conversation on virtual space and what the center is doing. Look out for the guidelines and protocol on virtual hearing that will be coming up in the next month. And let's keep the conversation on the continent on virtual hearing uplifted so that we can build the fast pace that Kamal has urged us to pursue. Thank you to the participants for spending time with us this morning. We do not take it for granted that you have made time to be on board with us and keeping with us throughout the hour. So John, thank you too for your hosting. Always a pleasure. Thank you.
Thank you very much. Thank you very much, Lawrence. Thank you, Emilia. Thank you so much for joining us. Thank you for Kamal, as always, for sparing your time and giving us your thoughts. It is always a pleasure interacting with you. It was really, really my pleasure moderating this session and hosting it. I regret that we could not have Professor Gidum Wigai joining us, but I'm sure that we will have another opportunity for him to join us. As Lawrence has said, we are looking to have another webinar, and perhaps we will be waiting with bated breath to see who will be on that. To the participants, I want to say thank you so much. I can see that we are joined by many practitioners, private practitioners, names I recognize. I see also a couple from the office. I see also counsel from various state corporations. Thank you so much for finding time, sparing time to be with us. I hope the session was useful. I hope it was interesting for you. And I certainly hope it was time well spent. My name is John Ohaga, and it was my pleasure interacting with you. Enjoy the rest of your day and stay safe. Thank you very much.
Thank you.